Thank you, everyone, for joining us this morning. Welcome to Brownfields 101. I'm going to be talking about considerations for brownfields acquisition and development, history of brownfields, and what to do if you're wanting to buy a contaminated property. We've got over 80 people in the webinar, so I suspect we have a range of experiences and expertises here. So this may be basic for some of you, new for others. Emma, you want to give us some housekeeping?
Yep,
notes?
Thank you. So, hi everyone. As I've been saying, we are going to use the chat pane for questions today. If we have a little bit of extra time, we may call on folks and you can use the raise your hand button, which is at the top of your screen, to be called upon. It looks like Teams didn't like my settings, so you are able to unmute yourself, but we ask that you please do not unless you're called upon, just to reduce any background noise to make sure that we can hear Mary as she's going through her presentation. So please remember to keep yourself muted unless you are called on to speak, and put any questions, if you're having any technical difficulties, feel free to put those in the chat so that we can respond to you. I will also be sending in the chat a link to this presentation. It's on the EPA website, and I'll share the link so that you can follow along on your own computer if you'd like to do that as well. I think that's all I have. I'll pass it over to Brittany quickly for her introduction.
Yes, thank you. Hi, everyone. Good morning. Welcome, and thank you so much for joining us today. My name is Brittany Nadler. I'm a Brownfields project manager with the US EPA in Region 5, and I've also been managing the technical assistance project that this training was born out of. And so I wanted to give a very quick background on how this project came to be. Every year at EPA, we have what's called technical assistance funding, and it's not a grant, it's not competitive funding, it's just money we have available to use internally for our regional priorities. And through that funding, we're able to work with communities across the region and consulting teams like ADAPTA on really important projects, such as funding charrettes, environmental action planning, market analyses, and trainings like this one. So we've actually been working with 2 counties in Michigan, focusing on affordable housing and Brownfields 101, and the ADAPTA team was able to give this training to them about 2 weeks ago now. We got a lot of great feedback, and now we're ready to share it with a wider audience. We have another training tomorrow focused specifically on housing and finance, and I'll be sure to share the link in the chat if it hasn't been shared already, so you can register for that one. Slides are available on our website right now, so you can follow along with those, and the recording will be available sometime, hopefully in the next few days. We'll have that on our website as well. If you have any questions, feel free to put those in the chat, and thank you again for joining us. I'll turn it back over to Mary.
Thank you, Brittany. And I want to thank EPA for sponsoring and funding this technical assistance project. As Brittany said, we gave Michigan 2 weeks ago, and Brittany wanted to open it up more broadly to Region 5. So thank you to EPA for that. I believe we have folks from Tetra Tech as part of the meeting as well. We are a subcontractor. ADAPTA is a subcontractor to Tetra Tech under this training, and we thank and welcome the Tetra Tech folks here also. My name is Mary Hashem. It's a small woman-owned business that I founded 8 years ago to focus on providing small communities nationally based on.
Hey, Mary. Your sound is a little bit in and out.
Okay. Is this better if I get closer to the mic?
Yeah, I can hear you now. I was hearing you just cut out a little bit, but that sounds good.
Okay, thank you, Emma, and apologies for the technical difficulties. So I was just saying that I founded ADAPTA 8 years ago to have a vehicle to provide technical assistance and sort of lessons learned based on my career in brownfields over the last 30 years, initially as a consultant, then for the last 25 years, actually buying, cleaning up, and redeveloping sites nationally. So that is the basis of and what I hope to share with you today. Who will be presenting the housing funding and financing webinar tomorrow. Tom may, if I miss something, chime in, but primarily you're going to be listening to me. We will have a few points in the presentation for a break because this is scheduled to be rather long webinar. I'm hoping we won't need the full hour and a half, but I wanted to allow plenty of time for questions. So there are a couple of points between the modules and the presentation where we'll break for questions. As Emma said, put your questions in the chat at any time, but during the Q&A, if you'd like to raise your hand and unmute, we can have a little bit of a dialogue. So what we're going to go through today is a very basic introduction to brownfields, and then talk about the initial parts of due diligence on brownfields, how to assess environmental conditions on a brownfield or potential brownfield. And then we'll talk a little bit about the real due diligence as part of acquisition, ownership, and management of a brownfield property. So let's get into it. The interesting thing to me has always been that in EPA's definition of a brownfield, it is the presence or potential presence of a hazardous substance. Therefore, you don't need to know that a property is contaminated in order to qualify for brownfields technical assistance and funding. Or a nonprofit, most of these technical assistance funds and EPA grants to private entities, but if you are either a consultant to a municipality, or if you are a municipality or a nonprofit, there is a wide range of support for phase 1 and phase 2 site assessments available through EPA. And just a potential brownfield. So brownfield, the term came into use in the early 90s. There are a couple of people who are credited with coining the term, but I suspect that may go as an urban legend or unknown for certain. But it did come into use in the early 90s, and EPA, in response to some of the liability concerns that were generated through Superfund laws, recognized that CERCLA had created a liability framework that was having a chilling effect in the market for transactions and redevelopment of contaminated or potentially contaminated sites. And therefore, EPA stepped in first to create some grants to help assess potentially contaminated sites, and later through the Brownfields Revitalization and Environmental Restoration Act of 2001, create some liability protections, a framework for innocent purchasers, and significantly increased funding for brownfields. What causes brownfields? I think all of us, have them in our communities, recognize them when we see them. And it can be anything from an old manufacturing facility that has become surplus real estate for a company because of a neighborhood dry cleaner that has, economic trends, market trends have made it an obsolete business, or the owners have passed on. And yet, because of the contamination, the building sits there. It can even be as simple as asbestos and lead-based paint in a former building that makes it financially infeasible in the regular real estate market to abate that asbestos and have a productive or adaptive reuse of a building. There's also, the legal concerns that have resulted in an abundance of brownfield sites. It becomes very, very difficult to finance brownfields. Anyone who has had direct experience in transacting a brownfield site, buying, selling, or being some sort of consultant or advisor to a transaction knows that it is very, very difficult, at times impossible, to find traditional sources of funding for brownfields acquisition. There's also a tremendous amount of sites that are located because of our history of development, redlining, and where industrial sites were tended to be located in communities. A lot of these sites are located in environmental justice communities and the communities that suffer from a great deal of disinvestment historically. And so it is somewhat adding insult to injury, and that some of the hardest sites to address are often in some of the communities that need them addressed the most. So what do brownfields look like? It can be anything from your classic, manufacturing site, abandoned smokestacks, industrial equipment, to a neighborhood dry cleaner, to open space. The lower left-hand picture on your screen is also a brownfield site. It's a landfill. They often get repurposed for use as golf courses because it is not as difficult to use the property where you have a lot of subsidence, where you have a lot of off-gassing. And so you sometimes see golf courses or parks over old landfills. It can be your local former gas station or just office buildings. Again, the asbestos can create a situation where that's a brownfield site, even if it just looks like an old office building. So there's lots of improvements to human health and the environment. These properties are a source of contamination and often are difficult to secure. And there are many, many sites that we have either acquired or have worked on where there's a lot of trespassing, there's a lot of exposure to unregulated contaminants at a property. They serve as a blight and have, again, a chilling effect on redevelopment and revitalization in the area where they're located. So the ability to address brownfields, to clean them up and ultimately redevelop or reuse them in some way, removes that blight, spurs revitalization, and vastly improves human health and the environment based on removal of contaminants, removal or control of exposure. And we'll talk about that a little bit later. It also leverages tremendous amount of private investment. But there is something like $20 in private investment leveraged for every dollar of EPA funding toward assessment or cleanup of a brownfield property. Creates jobs and increases tax revenues when there is an economic reuse of the property, such as for even housing, but retail or commercial use. And it also provides opportunities and land for community benefits. In many communities, land in desirable areas, otherwise well-located property, is constrained. And so the ability to provide even parks or open space or community facilities like libraries or health centers, brownfields can provide an opportunity for that development option for communities. For those who don't know, EPA has really focused in recent years on environmental justice, and the Justice 40 initiative has made it a goal from the federal government that 40% investments flow to disadvantaged communities. And that's all federal programs, not just EPA. So if you are involved in HUD or EDA or provide funding for land reuse or revitalization, 40% of those projects are now targeted for disadvantaged communities. And there's also been a great focus on creating EJ centers. I don't believe the grants have been awarded yet, but there was recently an RFP out, which I think got tremendous response for creating environmental justice resource centers within communities in all EPA regions nationally. And Brittany, if you are aware if those grants have been made, maybe either speak up or put it in chat. But there are going to be EPA contractors very similar to the TAB program, the Technical Assistance to Brownfields program, if you're familiar with that, that will be solely focused on providing technical assistance to EJ communities and rural communities. There's also USDA rural funding. And we'll talk about this a little bit more tomorrow. Tom Carell has a tremendous amount of information on funding programs, largely to support housing, but USDA also has funding available for some housing and also infrastructure and business support programs. One of the challenges with brownfields often is aged or obsolete infrastructure. And there are a number of federal programs outside of EPA that offer assistance and funding for addressing the infrastructure needs. So a lot of the times when we are redeveloping a brownfield site, it is that infrastructure improvement, anything that involves being in the dirt. So if that's installing a new water line, a new sewer line, new roads, curb and gutter, undergrounding electrical utilities, creating clean utilities in the dirt, if you will, on a brownfield site, even for site preparation and land development on a brownfield site, there are sources of funding through other federal programs available for that. And I think Tom will have more information about those sources and how to apply for them tomorrow. So with that, I want to pause to take some questions. Do we have questions in the chat? So now I'm going to talk a little bit about property assessment and how you go about assessing environmental conditions on a property. This is undoubtedly very familiar to a lot of people on this call. But I have found over the last year of giving this presentation or one very much like it, that even people who are familiar with phase ones may not be familiar with the nuances of all appropriate inquiry, or they may not be familiar with some of the nuances around the ASTM standard for phase one site assessments. So we're going to go through this again at a 101 kind of level, but even if you're familiar with phase ones, and you may learn some things here. So what does all appropriate inquiry mean? As part of the brownfield laws that came into effect and the liability protections, the EPA relied on ASTM, the American Society of Testing and Materials, for creating a standard practice for a phase one environmental site assessment. Prior to that, which happened in the late 90s, it was a little bit like the wild, wild west of people performing site assessments. And I was part of that wild, wild west back in the early 90s, working for a consulting firm, doing pre-acquisition. There was no standard. It was all over the board, and the results varied widely. EPA got engaged as an advisor to an ASTM committee to create a standard practice that the federal government could rely on to say, if you conduct these steps, you will have been deemed to have done all appropriate inquiry and therefore be eligible for liability protections under CERCLA. And again, CERCLA is the Superfund law that created this liability framework that had scared so many people off of buying or lending on contaminated property. There are other elements to all appropriate inquiry. While it's used somewhat synonymously with a phase 1 site assessment, there are some nuances here that you should at least be aware of. So just to make sure we're clear on terminology, a phase 1 environmental site assessment is largely a paper study. And it does involve a site visit and interviews, but it involves a lot of research into historical documents, title, uses, sandboard maps, aerial photos, a lot of investigations, and the classic, database survey, which often takes up, 100 to 200 pages of what's otherwise a relatively small report. Phase 2 environmental site assessment means some sort of intrusive sample collection and analysis to test environmental media, whether it's soil or groundwater, etc. There can be additional investigations as part of a phase 2 that would include assessment of lead-based paint or asbestos or regulated building materials, or in some areas of the country, mold. Those are not covered by the ASTM standard, but have become somewhat standard practice in a phase 2 for additional testing where warranted. So what's included in a phase 1? Site visit and site reconnaissance. This can be very difficult if you have a large site, and if you are retaining a consultant to perform a phase 1, you want to make sure that the scope and the budget is adequate to address the kind of site that you're dealing with. If it is a particularly large site, you want to make sure that there's adequate funding and resources available to really investigate that site. I have served as an expert witness on a case where the environmental consultant had difficulty accessing a portion of the site and simply didn't look down into a ravine where there were buried drums of hazardous materials and hazardous waste from an industrial operation nearby. And it created a tremendous, like tens of millions of dollars of liability for the owner who purchased it. These are the standard elements of a phase 1: historical records, the databases, etc. Phase 1 should have both findings and recommendations. Many users of a phase 1, at least in the private sector, will often try to talk the consultant out of actually including recommendations. I strongly advise against that. You want to have the recommendations of in the phase 1 document. In ruling out the likelihood or presence of any environmental issues. In that case, your suspected brownfield site becomes a clean property and you have removed the stigma. That's a huge benefit for communities if they have a site that people have been shying away from because they think it's contaminated. A phase 1 may rule that out and tell you, no, you really have a clean site. More often, it identifies some conditions, and these are categorized as a recognized environmental condition, which is there's something on the site or on an adjacent site that is a condition that could impair the property, and it's there today and it's recognized. A historical wreck is something that was there previously but has been addressed. So for instance, a leaking underground storage tank that has been removed and received closure and was cleaned up, that would be identified as a historical wreck. Used to be there, it's not there anymore. A controlled wreck is an environmental condition that was present and is still present at some level, but is controlled either through engineering or institutional controls. So if there had been an area that was known to have been a surface impoundment of some sort and it was closed and capped, that would be a controlled wreck. Didn't remove the contamination, it's still there, but it's controlled. A phase one should also identify any data gaps. And this is critical. Sometimes previous owners are not available for interviews. Sometimes there is a gap in the historical record, either in title or in aerial photos where there's a significant change in land use jump between years and you can't really say what happened in those intervening years. Any kind of data gap should be identified by the consultant in the phase one. And then there's considerations outside the scope of a phase one. And all of this comes from the ASTM phase one standard practice. If there is specialized knowledge or experience of the user, remember the user is the entity that is obtaining the phase one, has hired the consultant. If that user grew up in the community and knew what happened on that property, even though there's maybe no historical record of it. Maybe they had a relative who worked at that factory in the back 40. That would be some specialized knowledge of the user. There's also a consideration of the relationship of the purchase price to fair market value. If you are buying what would be a $10 million property, if it were clean, for $1 million or less, that should be a red flag, that there's some impairment to this property. And even if a phase one doesn't identify anything, if there's a significant market value of a clean property and what the purchase price is, that is a special consideration. And also commonly known or reasonably ascertainable information. Again, this sort of infamous site in the community. These are all things that if present, even if you have a phase one that doesn't identify any RECs, any recognized environmental conditions, can actually void your liability protections under all appropriate inquiry. So the identification of data gaps and some of these considerations outside the scope are critical to keep in mind as you're reviewing a phase one site assessment, particularly for anyone who is going to rely on it for those liability protections. The other consideration is that a phase one has a shelf life. It's a snapshot in time. So it tells you what's happening and the condition of that property at the time the inspector visited it, at the time the site visit and surveillance was done, or at the time the database report was obtained. After 6 months, you have to have it refreshed. So if you are acquiring a phase one for all appropriate inquiry purposes to buy a property, and you get EPA funding and a targeted brownfield assistance that the EPA regional office sends their contractor out and does a phase one for you, but you don't actually acquire the property for more than 6 months later, that phase one has to be refreshed. And after a year, it has to be done all over again. And of particular note is that clock starts not at the date of the report, but when the last investigation was performed. So whether that was the site visit or the date of the database pull, the key elements that are time sensitive, and a environmental consultant going out and doing surveillance and doing a site visit and inspection, and the date the environmental records the database report was obtained. That's the date that begins the 6-month clock, not the date of the report. This is a little factor that is often overlooked. And I have known situations where communities have applied for brownfield funding only to discover that their phase 1 that they thought was within 6 months is actually out of date because they were relying on the date of the report. Phase 2s, as I noted, and we won't talk a lot about this, but it's basically actual testing and data collection of environmental media based on the findings of the phase 1. So if the phase 1 indicates that, this was a dry cleaner, or this was a manufacturing operation that had floor drains, or a paint shop, or an automotive use where there was underground storage tanks, or you'd expect that there should be underground storage tanks, but none are recorded, they'll recommend phase 2, and that is most typically soil and groundwater testing. Although depending on the site and the conditions, it may include surface water. If there is surface water nearby, it may include soil gas. And as I noted earlier, even though it's not part of the ASTM phase 1 standard, it can include building materials such as asbestos, lead-based paint, etc. The primary goal of the phase 2 is either to confirm the presence or the absence of contaminants that resulted in a wreck in the phase 1. So if your phase 1 said, this is a recognized environmental condition, you need to go do a phase 2. The main purpose of that phase 2 is somewhat cursory. Let's see if that wreck exists or not. If the suspected contamination is not found, then you don't have to do anything further, and the wrecks you'd consider them resolved. But if contamination is found, then in most cases, you're going to have to do additional investigation to completely define the nature and extent of that contamination. Will not answer all the questions in 9 out of 10 cases, unless you do an extremely extensive phase 2. If you're pretty certain that contamination is there based on the history of the site and the findings of the phase 1, then it may be appropriate to do a relatively extensive phase 2 site assessment that would answer those questions. But in most cases, that is not the approach. It is a scope of a phase 2 that is more scaled back, that is really just going to say, okay, we think there might be some volatile chlorinated compounds here. Let's go see. Let's take a groundwater sample. Let's take some soil samples in the areas where we knew these operations took place and see if there's something there. And then if there is, then you go back out and you design a field investigation that will help you completely define the nature and extent of that contamination. So this is just a little flow chart that kind of summarizes the steps and the decision points. Again, you will have access through the link to this presentation, and it's just sort of an easy cheat sheet. So let's pause there again for questions.
Any questions that was about the timeline and just clarifying it's based on when the records are ordered. I'm not sure I understand exactly.
It's the timeline based on when the first record review is made, even if records are being requested reviewed. No, I believe it's the database search. So whatever company you're going to get the database search, you may still be requesting records from a local agency, and those may be a little slow to come in, but the date is going to be triggered by the later of the two key elements, which is the site reconnaissance or the database report.
Just get back.
You bet.
presentations available.
I did, yeah. So, yes, I think Brittany just posted the link in chat to the full presentation.
Refreshing phase one for 6 months and doing a phase one. What's the difference?
So the question is the difference between refreshing a phase one after 6 months and doing a whole new phase one. The difference is in a refresh, you're simply pulling a new database report to see if there have been any new sites listed, any new releases reported, and doing another site visit to examine the current status of the property. When you redo the entire phase one and you do a new one, you're going back and re-interviewing people, you're going back and looking at Sanborns, you're going back to all of those, the site visit and the database, but also rechecking all of the historical records. Any other questions? Okay. So this next module is going to address the actual purchase of a property. So this will be from the perspective of a municipality, a nonprofit, any sort of quasi-governmental entity like a community development corporation or an urban renewal authority that is going to be acquiring property through a standard purchase and sale process. There's a little bit of nuance and differences for eminent domain and other forms of acquisition of title through things like donation and inheritance. But I'm not going to address that. We're going to just focus on the standard acquisition process. So what do you do pre-acquisition? What kinds of things do you want to make sure you're paying attention to before you take title to a contaminated or potentially contaminated property? You want to do comprehensive due diligence, and this is beyond all appropriate inquiry. All appropriate inquiry in your phase one, in my mind, is always sort of the basic must-have, necessary but not sufficient, if you will. Some form of financial analysis is needed to make sure that you have the funding to complete the project you're envisioning. You want to look at environmental liability and regulatory considerations, and we'll talk a little bit, although I'm not a lawyer, caveat here, we'll talk a little bit about some legal and contractual terms that may be a little different in a purchase agreement for a contaminated property than a standard property, and we'll touch on environmental insurance. So, comprehensive due diligence, what do I mean by that? In a standard purchase and sale agreement, you're going to have some form of inspection period. It can be a contingency period, typically specified in the purchase and sale agreement. It is standard that there would be some form of deposit, which is considered a soft money deposit, i.e. refundable, in the event the transaction is not completed. And you typically have a contingency period that is specified in the contract, wherein at any point during that period of time, the buyer can elect to terminate the acquisition for any or no reason, and they'll get their deposit back. That's also the date. The end of that inspection period is referred to as the date when the money goes hard, which is to say becomes non-refundable. At that point, if the transaction is terminated by the buyer after that date, they lose their deposit. So you want to have, as a buyer, as generous and long a due diligence inspection period as possible. You need to think about what level of site investigation you're going to do during that inspection period, there's often a disconnect between what is desired by the buyer and what will be allowed by the seller. We have worked with many sellers who, are nervous about someone, even someone they're under contract with, coming onto their property and taking samples and doing inspections. We're even working on a site right now where the owner is not allowing any inspections. They are not allowing any testing to be done on the property. That is likely going to kill the deal. It is difficult enough buying a contaminated piece of property. Buying it without being able to ascertain the level of nature and extent of contamination means you can't adequately budget for cleanup, and you can't underwrite environmental insurance, at least not insurance that's going to be worth the paper it's written on. So there has to be an agreement between buyer and seller about what's going to be allowed. Sometimes sellers will say, you can come collect the data, but I don't want to know about it. It's a don't ask, don't tell. They don't want to become informed if you confirm that their property is contaminated. And they often will want to control communications with regulatory agencies during the due diligence period. So when I talk about financial analysis as part of due diligence, this is usually, starts for us prior to entering into a purchase and sale agreement with some sort of what we call back of the envelope calculation, making a whole lot of assumptions about what cleanup may be required and what property value is going to be at the end of the day and what it's going to cost to get it there. But as the due diligence period progresses, you become more and more certain about every element of those project costs, both environmental and non-environmental costs, such as, engineering and geotechnical and hard and soft costs for development. Ultimately, before we actually close on and acquire a property, we want a pretty good, thorough, reliable project pro forma, which is to say a spreadsheet that tells you the sources and uses of funding, that tells you the timing of when you're going to need what funds and how much, and the duration of the project. The timing is important because returns calculated on any kind of investment like this are time-based. Investors will often have metrics such as an IRR, an internal rate of return, that is very time sensitive. And if a project takes 2 years instead of 1 year, your IRR will be cut in half. It's a very one-to-one relationship between the time it takes to do a project and the calculated IRR. So when you hear about investors wanting a higher return because of the higher risk on a contaminated property, the returns they're talking about are either IRR based, which again is a function of time, or they are some multiple return on investment. Most investors will look to a 2x return, like twice the amount of money that they invested, they want as a return. And there are other metrics that investors have for the returns they're expecting for investing in a real estate development transaction. But IRR is the big one. And again, timing really influences it. So a project pro forma that is not just a static model, not just, I'm going to put this much money in and I'm going to get this much money out at the end, but that actually looks at the time it takes to do that and spreads those costs out over the time when they're expected to be incurred, is very critical. And then the sources of revenue is always the big challenge. There is a certain amount of private developer equity that goes into any real estate transaction. And that's true whether it's, us as a private development company buying the property or a municipality or a CDC. There's a certain amount of money you're going to have to spend in soft costs, in staff time, in consultants, or in hard costs for, testing or equipment or, actual investment in the property to determine what that whole project is going to look like. And you can model it for any endpoint. It can be modeled for just an acquisition, cleanup, and sale, or it can be modeled through a whole redevelopment project. Obviously, the amount of information you need and the time involved is very different depending on what your project is. Is your project just site stabilization? Is it buying it, cleaning it up, getting it to a point where, another developer or buyer is going to be willing to buy it for development? Is it doing infrastructure and reconnecting a street grid and curb and gutter and sewer and utilities, and then selling a developable piece of land, or taking it to the next step, getting project entitlements and grading and having buildable lots that are basically ready to go for any kind of particular development, depending on what it's owned and entitled for. So there's a lot of nuance here. There are a lot of resources available to help with that financial analysis, but it's really important to understand where the money's coming from, where it's going, and over what period of time, to make sure that your sources and uses are lining up, not just in total dollar value, but in timing for what you need to use them for. The other thing pre-acquisition you need to understand is the form of environmental liabilities you'll be stepping into. And this can be both federal and state. I've listed most of them here. I'll be happy to answer questions about any of them if you have them. I'm not going to go into a lot of detail about them. And we will talk a little bit more on regulatory perspective of making sure you understand which of these programs here apply to your site. If you are a RCRA site, you are not eligible for, in most cases, not eligible for brownfield funding. So, there are RCRA liabilities out there, but you will probably not be dealing with them if you're looking at a brownfield site. You want to understand the cleanup requirements and other forms of liability that extend beyond just the regulations and laws. And this is tort liability, for those who are unfamiliar with the term, is sort of a civil liability from by a member of the public or a neighbor or someone who comes onto your site for some sort of personal injury, damages associated with the presence of contamination on the property. And there is insurance for those kinds of liabilities. And we will go into the long-term obligations later in this slide deck. So to speak to the regulatory considerations, the best thing you can do is get to know your regulators. And you have at least one, if not more of them, on the phone here today. Both state and EPA regional offices are a great source of information, support, technical assistance. There are a number of EPA programs, the new ones coming up all the time. And these are the folks who are going to know about them and who are going to be able to direct you to those resources. As I noted earlier, there's different kinds of environmental liability, different agencies that will have influence and jurisdiction over a particular site. So you need to determine the appropriate regulatory program that this site you're thinking about buying is going to be enrolled in, is going to be governed by, whether it's a voluntary site, whether it's a surplus site. In some cases, there are local environmental agencies that may take a lead. You need to figure out who your lead regulatory agency is going to be. And you need to meet with those folks, get to know them, and reach an agreement on what needs to be done to clean up the site. We do this pre-acquisition on all of the properties we buy, which is to say we want to understand we're a responsible buyer and we want to reach agreement on what has to be done once we buy this property, what's going to be necessary to get it clean enough for our intended reuse. So that means, what's the cleanup action? Is it dig and haul? Is capping an option? What kinds of mitigations are going to be necessary? What cleanup standards will be applied? Has the site been adequately characterized, or does the agency think that more investigation needs to be done? That's an important question early in the process. A lot of these sites have already come to the attention of somebody, either at the local, state, or federal level, and it's good to know what information is already out there. So once you have reached that agreement, you need to memorialize it in some way. And depending on the regulatory program you're in, it can be a variety of different documents. But the bottom line is, you want to make sure that that agreement is captured in writing pre-acquisition. You want certainty before you buy this property. Staff changes, staff at the agencies change, people retire, get reassigned, move. Same for, the buyer side. People change jobs, people retire, and you want to make sure that there's an agreement in place that is going to survive whatever individuals were present at that table when the agreement was reached. You also need to know very early on if there's going to be any land use restrictions at the property. Again, before you buy, you need to know if that cleanup approach is going to result in a capping or containment strategy. If there is a vapor intrusion issue, if you have vapor encroachment from an adjacent site and you're going to have to design vapor mitigation into any building that's built on the site, if there's going to be land use restrictions against withdrawal of groundwater, control to industrial commercial uses, restrictions against sensitive uses, restrictions against digging, against any excavation on the property or excavation only with notice. Whole range of standard land use restrictions that are put in place on brownfield sites, particularly if you're doing a risk-based cleanup, particularly if you are leaving some contaminants in place that are deemed safe for the intended reuse. There has to be some land use control that makes sure that that intended reuse is in fact the use of the property, and that, some number of years down the road, that somebody doesn't decide to go build a daycare center on your site. Those are all things that need to be understood pre-purchase. Obviously on the legal side, you need to have an attorney involved, whether it's your city attorney or an environmental attorney that is retained by your city attorney, or just your general counsel. You want to think about who's buying the property. Whoever is buying this property is stepping into liability or potential liability. And while you do everything you can to manage that liability in the form of appropriate due diligence and qualification for all of the innocent purchaser liability exclusions, and maybe environmental insurance, it is still wise to be thoughtful about the entity that is going to take title to protect a city or a nonprofit from that liability. You want to think about indemnifications and releases. This is always a big point of negotiation in any purchase and sale agreement. Who is going to indemnify who, if anyone? As indemnifications are not required, but often are requested by either a buyer or seller. An indemnification, is basically means that the entity providing the indemnification is saying, I'm going to guarantee you that if there's say an environmental issue here that arises, I will take care of it. I will be the backstop. I will respond. A release is softer than an indemnification. A buyer will often be asked to release the seller from environmental claims. It's not saying that the buyer will provide an indemnification. They won't necessarily step in if a third party makes a claim against that seller, but they're saying that I'm going to release you. I, as the buyer, will not come back against you, the seller, with claims for additional contribution for environmental conditions. You also want to think about limitations on the liability being assumed. There are a lot of ancillary liabilities that can come with a property that you as a buyer don't necessarily want to assume. In the case of an operating site, a site that had employees and had some forms of operation on them, maybe generated waste, there are liabilities associated with that operation that you as the seller want to specifically exclude from assumption. For instance, any worker compensation or claims by a worker that may have been exposed to hazardous materials in the workplace. You don't want that liability. Any disposal facilities, if the site generated hazardous waste in the past and shipped it off for disposal, and where it went becomes a Superfund site or requires cleanup, you don't want that liability based on the prior operations. There are a whole basket of liabilities that should rightly stay with a seller. And again, consult your attorney, make sure you have a good environmental attorney who understands these liabilities and can protect you through the contract. To the extent that you are assuming some liabilities, you want to limit them to the best of the ability in time. You don't want an open-ended, in perpetuity kind of liability assumption. You may want an assumption for a certain number of years or up to a certain dollar amount. And those are all things that should be considered during the contractual negotiations. You want to make sure on title and survey, you want to make sure you resolve any title issues before you buy the property. I've had properties we've bought where, just particularly on older sites that have had operations for decades, it's amazing what can get put on title, and it can be extremely difficult to resolve some of those title issues, because sometimes those entities that entered into the deed restriction or the easement or whatever may not even exist anymore. And so if you have an older industrial site, make sure you're allowing time to address the title and survey issues. And then there may be some constraints around communication with regulatory agencies. Again, the seller may have certain restrictions or certain requirements they want to place on your ability to communicate with regulatory agencies. That's something that needs to be agreed upon and incorporated into the purchase and sale agreement as part of the negotiations. So let's say you've done all of that and you've bought yourself a handsome brownfield site, and now you want to make sure that you're managing your risks after you own it. We have found there's a few really great ways to manage risk, and the best way is cleanup. Whatever is the source of that risk, either remove it or control the exposure. Controlling the exposure is obviously a risk-based cleanup, that you clean up to a standard that is appropriate for the reuse, or that you put engineering or institutional controls in place to control exposure. The other big thing that we have found in managing risk post-acquisition is actual redevelopment. You would be amazed how short people's memories are. One of the very first big brownfield projects I did back in the early 90s was acquisition of a refinery and bulk storage terminal north of San Francisco. And after demolition of the refinery, remediation, it was redeveloped into housing, into a development called Victoria by the Bay. And the people who live there now, I will just about guarantee you, have little to no knowledge of the environmental history, or that they're living on what once was a refinery. So obviously, cleanup and regulatory closure are critical to the to removing environmental liability post-acquisition, but redevelopment really will remove the stigma from a site. And the last thing we want to talk about is continuing obligations. All of the liability protections that we've been talking about that are available through the CERCLA rule, and innocent purchaser, bona fide prospective purchaser, all of those come with a little bit of lingering requirements. And these are termed continuing obligations. It may be operation and maintenance of the property in cases where it's a risk-based cleanup and there's some amount of contamination left in place, or there's some engineering controls. You may find that there's some requirement for affirmative property management or materials management plans for maintenance on the site. That can include, you know, repairs to utilities, installation of new landscaping, installation of a new parking lot or lighting, whatever it is. Ongoing property management and ongoing materials management are often important on brownfield sites. If you want to maintain your liability protections, you have to continue to comply with environmental regulations. And that can include things that you may not normally think of, but like stormwater management. If there are any site monitoring and reporting requirements, perhaps you have a requirement for, you know, annual or biannual groundwater monitoring as part of the closure, or maybe there's CAP inspection and reporting, or maybe annually or biannually you have to report and certify that the land use restrictions and restrictions to commercial industrial use are being maintained. Whatever that is, you want to make sure that you keep up with all those reporting requirements. You have to allow access as they request to any lead environmental agency for inspection of the site. And there's a clause that requires use of appropriate care when using any hazardous substances or discovering any hazardous substances found at the property by taking reasonable steps. These are really squishy terms. These are not particularly defined. These are some of those, you know, legal terms that, you know, if you get in a situation where someone is asserting liability because you failed to take appropriate care or failed to take reasonable steps, you'll be arguing, the lawyers will be arguing ad nauseum for years probably about it. But it is somewhat common sense, but just be aware that there are continuing obligations and requirements for management of the property for you as the buyer or any future buyers to maintain those liability protections. And then the last thing we'll leave you with is other kinds of considerations for ownership. And some of this is standard ownership of property, you know, standard property and liability insurance. Vacant buildings are an attractive nuisance, even vacant land. So site access, control, and security can be expensive, but can be important depending on the nature of the hazards that are present. We worked at a site in Montana where there was an old smokestack that had become a really popular place for kids to climb to the top of and slide down. And there was a teenager injured, and he was okay at the end of the day, but you know, that kind of trespassing, sometimes called urban exploring, urban spelunking, the buildings that get tagged and, you know, stripped of copper wire, and it's amazing what people will do, and the curiosity around a vacant building. So make sure you've given appropriate thought and dollars to securing the site once you own it. And you have to consider carrying costs. Some of it will be a little bit more on an environmental site. Insurance may be a little more expensive. It's often difficult to get property insurance for a vacant property just because it tends to attract vandalism and potential liability. But things like, stormwater management, weed abatement, these are all carry costs that need to be considered depending on the kind of property you're buying. So with that, I want to open it up to questions.
Did get one question earlier about properties with existing environmental insurance.
And what was the question?
Was
Oh,
how about old insurance on the properties?
okay. So how about old insurance on a property? So prior to the CERCLA regulations, GL, general liability insurance, covered environmental releases. And as environmental laws, became more clear and more stringent, insurance companies started putting exclusions in their policies. And over the course of about 5 years, went from modest exclusions to complete pollution exclusions, such that any general liability policies purchased after the, I want to say, mid-90s, you no longer have any coverage for environmental in those general liability policies. But prior to that, those general liability policies did cover environmental releases. And so there is a whole practice of law that is insurance forensics, that there are attorneys you can hire whose sole practice is to go look for those old insurance policies because they were unlimited in time. And so if a prior owner had a general liability policy that included pollution coverage, you can sometimes make a claim on those policies even today. And so it's a very viable source of funding. There are some constraints. Typically, these groups that do it will take a percentage of what they recover, and they will often, at no cost, assess the likelihood of recovery. So you can, have some initial discussions with them, give them the history of ownership, and they will be able to fairly quickly tell you if they think it's viable that there would be something to recover there. If they think there is, and they will do that work, and it is typically on a percentage basis of what can be recovered.
Come in.
I really didn't talk a lot about environmental insurance. That could be a whole nother hour. But if there are any specific questions about it, feel free to raise your hand and unmute if you'd like to ask a question at this point. Happy to engage in a dialogue with anyone who has questions or wants some advice about a situation you're dealing with. Emma, I think we will call it then.
All right.
Thanks again, everyone.
Thanks, everybody.
Thank
you.
you. Bye.
Thank you.